Let me tell you something that I realized today during my ESL Methodologies 1 class. I'm a guest lecturer in my fellow professor and friend Dr. Burch's Test class. I was invited to talk about the most important legal cases in ESL and bilingual education history in the United States and the different programs that we have for bilingual education here in Texas. And then it hit me this question that we all need to be asking right now. Who is going to be in charge of protecting high quality education, equal access, and fair assessment for English learners? The Office of English Language Acquisition is closed. Now, who? Let's start with the law Nichols. This was the first major case that addressed the rights of English learners in public schools. The San Francisco School District was using a sink or swim approach, throwing non-English speaking students into classrooms without language support, expecting them to just figure it out. The Supreme Court said this was discrimination. Schools must provide meaningful language support to ensure English language learners can access education equally. Now, here's the issue today. OELA played a key role in ensuring districts followed this ruling. Now, without the Office of English Language Acquisition, who ensures that students don't get left behind? Fast forward in 1981, another fight, another case, Castañeda versus Pickard. Roy Castañeda sued his Texas school district because his children, Mexican American students, were in bilingual programs that didn't work. They weren't learning English. They weren't progressing academically. They were just stuck. This case set the standard for English language education. If a program is not helping students progress, it must be changed. Now, let's think about today. OELA ensured schools followed the Castañeda Test. Without this office, who is monitoring whether English language learner programs are effective? Then came Plyler and though Texas had passed a law that denied education to undocumented children. Yes, you heard that right. Schools were literally turning children away because of their immigration status. The court said education is a fundamental right. Schools cannot deny a child access to education, regardless of their immigration status. And now, without the Office of English Language Acquisition, will schools still uphold Plyler and Doe and ensure all education receive fair access to education? Will all English language learners lose resources, protections, and support at the state level? OELA has been the backbone of federal English language education policy. It ensured schools received guidance, funding, and accountability measures to follow these laws. And now it's gone. So I ask again, who is going to fight for these students? Who will ensure that promises of law, Castañeda, and Plyler are upheld? Here's what we can do, because silence is not an option. Stay informed, know what's happening at the policy level, advocate for funding, push for strong bilingual and ESL programs, hold schools accountable, ensure districts meet the standard of law, Castañeda, and Plyler, support educators and EL families, provide them with resources, training, and advocacy tools. These legal cases were not just victories of the past, they are protections we must fight for today. The elimination of the Office of English Language Acquisition is a direct threat to the future of English language learners in the United States. Let's keep this conversation going. What do you think needs to happen? Drop a comment below. Thank you so much for listening to me, and please advocate for your bilingual and ESL students. Like my friend Dr. E.T. said this time, calladitos no estamos más bonitos. Thank you.